Ladies and gentlemen, Professor, dear colleagues, and Mr. Director, I'm very, very honored being here, being invited to this conference. Thank you very much. The subject of my speech is the role of the Committee on the Rights of the Child, and this is the subject of my own chapter 2 in the book published by the CA. So I like to do everything to make my speech as short as it is possible. I don't want to be the theft of your coffee break now. I know that you are after the time according to our conference. More details about the matters I would talk about you may find in this chapter. I like to because of the short time, I like to express some main topics, some main questions in this subject, named the role of the Committee on the Rights of the Child. The Committee on the Rights of the Child was established under Article 44 of the 1999 Convention on the Rights of the Child. However, this doesn't mean that the issue of child rights protection wasn't the subject to other international legal regulation. The Convention on the Rights of the Child directly refers in the preamble to the most important international legal acts enacted earlier. These acts directly concern the legal protection of the Convention, protection of child and humans. They should be indicated because they are the background, something like background of the Convention on the Rights of the Child, and on the other hand, they are something like legal framework for child protection under international law, and directly determine the legal and institutional position of the Committee on the Rights of the Child. It's a very important topic to say about it. To make my speech shorter, as I said at the beginning of the speech, I only say that I only refer to some important international acts like Declaration of the Rights of the Child, Universal Declaration of Human Rights, International Covenant on Civil and Political Rights, International Covenant on Human Rights, and International Covenant on Economic, Social, and Cultural Rights. These are these acts, international law, from international law, which, as I said before, which are the framework of the activity of this Committee on the Rights of the Child. The Convention on the Rights of the Child of 1999 refers in its preamble to human, of course, child rights, and stated it the aforementioned legal acts, conventions. According to the provisions of these conventions, human rights must be understood in a realistic realistic, I mean natural law, realistic manner. This means that every human being, of course child too, has inalienable rights regardless of executive, judicial or legislative authority. These rights belong to every human being because of their inherent dignity. There is the position, of course, on the realistic natural law. Any other understanding of human rights always leads to the denial and violation of these rights. This note in this time, in the conference, in this point of my speech is necessary because there is currently a discussion also in the Committee on the Rights of the Child, which undermines the objective nature of human rights. Nevertheless, it cannot be ignored that any attempt to separate the acts of international law cited here from their natural law sources and foundation always leads directly to the relativization and anarchization of law. Consequently, instead of the objective legal protection of children's rights postulated in these acts, in the practice of applying the law, either every protected child right is directly denied or legal protection is overpowered in favor of ideological disputes. Why I'm talking about it here? Because it cannot be hidden that we are currently dealing in the subject of this conference too, but not only with the subject of the conference. We are currently dealing with a real war of civilizations, Unfortunately, the first victims of this war are children. The preamble refers to the foundation, which is inherent dignity. I'm citing inherent dignity and understanding at the value of the human individual, the family as the fundamental unit of society, and the natural environment for the growth and well-being of all its members, especially children. It was citing too. It emphasizes that the child, for the full and harmonious development of his or her personality, should grow up in a family environment, in an atmosphere of happiness, love, and understanding, and that the child, by reason of his physical and mental immaturity, needs special safeguards and care, including appropriate legal protection, before as well after birth. By the way, Janusz Korczak, very known for Polish children person, told the same, what is now described in international convention. This foundation is the reason principle and basis for the application of the convention and the legal existence of the Committee on the Rights of the Child. This is the most important interpretative criterion for the works of the Committee on the Rights of the Child. According to the Articles 43 to 45 of the Convention, the Committee on the Rights of the Child is a treaty body. The Committee operates within the competences and objectives set by the Convention and the optional protocols. The legality of the Committee's actions lies in implementing the competences assigned in the conventions. There is no room, I like to express this point, there is no room for presumed competences. In some cases, the committee's activities, such as lawmaking, named general comments, may appear controversial. However, the committee doesn't have legislative competences in the strict sense. Such competence violates the sovereignty of states parties to the conventions. However, there are situations where the committee usurps the right to binding interpretation of the convention's provisions. There is an ongoing discussion on this issue in legal science. The Committee on the Rights of the Child can only deal with matters to which the states parties to the convention have agreed. Provisions of the convention define these issues. The committee may not interfere with matters that fall within the sovereign competence of the state party to the convention. It isn't an authority or court in relation to the states. It only solves the problems through dialogue and communication. We can describe the competences of the Committee of the Right of Child. According to the short time, going to the end of my speech, I noticed some of these competences. Detailed, when we are talking about rules of procedure of the Committee on the Right of Child, all the detailed solutions are provided in the optional protocol to the Convention on the Rights of the Child. According to the first article of the protocol, the committee is competent only in matters concerning the states parties to the convention. What are the working methods, the main working methods? The chief working methods of the Committee on the Rights of the Child include state reporting, individual complaints, interstate complaints, urgent interventions, complaints about systematic violations, and these complaints are named inquiry procedures. Another working method is general comments, open letters, and statements, and of course, at the least, thematic discussions and conferences. According to the individual complaints, is a very interesting but a very wide subject to the discussion. Individual complaints, urgent intervention, and complaints of systematic violation named as inquiry procedures. Under the optional, I only say that under the optional protocol on notification, the Committee on the Right of the Child can receive and consider individual and interstate notification of violation of children's right. According to the general comments, I only say in the short way that the Committee on the Rights of the Child can make suggestions and general recommendations based on the information received in accordance with Article 34 to 35 of the Convention. And these suggestions and the general recommendations are communicated to the concerned state party and made known, on the other hand, in the same time, and made known to the United Nations General Assembly along with comments with the state parties. Making the conclusion of the subject, the role of the Committee on the Rights of the Child, the Committee should operate strictly within the express competences established by the Convention and the optional protocols. This is a condition for the legality of the Committee's actions. There is no room for presumed competences. Why I am talking about this presumed competences? Somebody can say that Mariusz Grabowski don't like presumed competences very much, but for me personally, the term, this phrase presumed competences, very known in the reality of working, for instance, United Europe. This presumed competences are based on the Marxist ideology, in my own opinion, that ideology named presumed competences is very dangerous for democracy in Europe too. The committee can only deal with matters that are referred to it under the provisions of the Convention. Therefore, the committee cannot interfere in matters that fall within the sovereign competence of a state party to the Convention. Moreover, the committee isn't an authoritative body over the status parties to the Convention, even in matters assigned to it by the Convention. Dialogue and advice are the way it operates. The Committee on the Rights of the Child is an important body that protects the rights of the children. It has considerable authority as a treaty-based body. Although the committee doesn't have executive competences, it significantly influences the application of the law. This can be seen, for example, in the introduction of subsequent provisions of the Convention and optional protocols in various countries. This influence is particularly evident in the application of laws. The general comments issued by the committee play an really important role in establishing the protection of children's rights in states. They create significant standards for legal protection. And I think that that's the main role of this committee, the Committee on the Rights of the Child, the role which we named as creating standards, international standards of legal protection of children's rights. Owing to the various activities described above, the Committee on the Rights of the Child contributes to spreading legal awareness in individual countries and internationally too. Thank you very much for attention. I really tried to make my subject as short as possible, so please, no, I haven't the possibility to say everything what I would like to say you, but the subject is very, very wide. Thank you very much once more.